You got to join us for this. Hey, LA, and those of you watching and listening all around the world. I am Zach Goldsmith alongside my first mate here, Ben Billick.
Ahoy.
And today, on To Live and Buy in Australia, we have someone here to keep your sweet asses out of jail, save your real estate licenses and a shitload of money in the process, and embarrassment. Although he will embarrass you on the phone. We'll get to that later. If you have a problem in life, you better call Saul.
Great job.
But in the world of real estate, if you have a problem, or better yet, to stop a problem from happening, Tel Aviv. I coined that, Tel Aviv. His name's Aviv Tuchman. LA, born and raised. Don't even attempt to talk during the intro.
Don't talk during the intro.
LA, born and raised. He left only for a short time for a stint at Berkeley, a Cal guy. I met him as the lead attorney for Hilton and Highland.
Oh.
Anything this guy said, Jeff Highland and Rick Hilton said yes to.
Except fire Zach.
This guy's tried more cases and saved more asses in this town than Johnny Cochran. When I see his name pop up on my caller ID, I get anxiety. I break out. I get red. And when I answer the phone, I'm scared. You'll see. He may look like a sweet little Mel Brooks, but he's fierce, okay? He's ferocious like a bull shark, as direct and straightforward as someone on the spectrum, with a bedside manner of a Vildachaya. What's a Vildachaya?
Not saying.
Don't speak during the opening.
He keeps interrupting the intro.
It means wild
It's
animal.
unprofessional.
It means wild animal.
It's unprofessional.
He's aggressive like a pit bull, but he's fair and he's straight to the point. And when there's trouble, real trouble, or you need someone on your side, there's no better person to have in your corner than this man right here. Ladies and gentlemen, our pleasure to welcome to the show. Get your pencils out for Aviv Tuchman, attorney at law.
Permission to approach the bench.
On the next episode of Tel Aviv, Bella gets caught with a lady hooker to sit on his open house. Take it easy.
All right.
Welcome, Mr. Aviv Tuchman.
Sorry. Listen, he tends to roast the people he likes the most on these. So, like,
Thank
if
you.
you can get past that, he actually has a lot of respect for you. He likes you a lot personally. Again, he roasts our guests. So, sorry.
You know, we don't need the bumper for him. This guy has no feeling.
I know Zach for many years, and Vildachaya is what he says about his kids.
That's true.
Well, that is true. I know them.
Well, I went to law school about 35 years ago, doing mostly litigation. I formed my own firm after about 6 years, figuring I could do a better job than anyone I was working for.
I love you already.
And I certainly have, and
Sling that dick.
Right.
I get it. I
So-
swing mine too.
We formed our own firm, and I've been doing real estate for a very, very long time, both transactional and litigation, and we try a lot of cases. I have a firm now with people who have been with me for many, many years.
Some of them who you brought.
Andrew John is here.
Andrew.
Mr. Andrew John, and
Represent.
and Michael DeCecca. And so, but they've been with me a very long time.
You roll deep.
So let's. The question that every agent wants to know is, where is the real estate agent's most vulnerable state? Do you think it's the disclosures? Is it the prelim, because they almost never ask an attorney to review the prelim? Or is it maybe misadvising which inspections to do?
Well, I think there's also a difference from a dual versus one side. But
Okay.
in general, I think the agents say too much. I think that they promise too much. I think that you need to recommend the appropriate experts relating to inspections. I think that if there are questions regarding legal matters, interpretation, or things relating to preliminary title report, the agent should recommend a lawyer.
Mm-hmm. See, that's interesting because this will come up a lot. Like, we are full service agents, and it makes me nervous. We are full service, and we want to be all knowing, and you want to have the answers, and your clients turn to you and ask you a question, and you want to deliver, but that often gets us in trouble. When do we call Saul?
Well, certainly you're right. When you look at the preliminary title report, if it's clean, then you can tell pretty much right away if there's a lot of liens. You can tell if there's a lot of things going on. If there's a lis pendens, a lawsuit pending, that's time to call a lawyer to find out what that's about. I think that many times if there are threats, then you have to call a lawyer. If you as an agent get a lawyer letter, you should have a lawyer respond.
Well, give us a quick briefing on arbitration mediation. The difference is when you come in.
A mediation is when it's you don't have to be bound by what the judge says or the mediator, but there's a recommendation to settle the case before litigation. An arbitrator is a contract to have someone decide your dispute. And when that judge or arbitrator decides and makes the decision, it can be enforced in court, and it's hard to overturn them. So mediator is more or less voluntary, whereas arbitration, the result will be compelled.
Right, and you're very involved, should be, in the mediation process.
Yes, I think that when you go to a mediation, you should take it seriously. There are car mediations, there are less expensive mediation alternatives, there are more expensive mediation judges. I think that there has to be a lawyer in general, that you should be prepared with a brief, and if there are issues relating to condition, then expert reports or repair reports are paramount to get an idea of the scope and damages.
So I want to talk about a couple tips and tricks here. I have two quick things. One, I just had dual representation on a property, and every single thing that we disclose, every single plan, everything, every bid, every report, I made them sign that they received at the buyer. Every single one. We've got like 3 of these standard car forms, receipt for reports, acknowledging that they had them, because I did not want anything that they said like they didn't get. Even when we updated the plumbing bid, we signed that we got the updated plumbing bid. Where do you see issues post-close the most? Like, is it survey? Is it lot line? Like, where someone would come after, generally speaking, in the residential space, where a buyer, now the owner, would go back against the seller? Is it disclosures or?
The first, I would say, issues relating to alleged conditions that the buyer is not happy with, or they think something is wrong. Then secondarily, disclosures regarding citations or previous history of losses. And then those are the 2 main issues between buyer and seller.
So you talk about previous history of losses. Does that mean that like maybe every transaction, the agent should be pulling a clue report to see what insurance claims have been made?
Well, I think that the agents have a duty to provide public information that they can access. I think that you need to talk to the seller to make sure as to what the history is, but mostly the seller must disclose, because the seller will know the history of the property. If you're an agent that's previously been on a transaction, or you've rented the property out, or you've been Airbnb, or you have familiarity with the property, I think it's heightened in terms of your knowledge.
When you are looking for some leverage at the beginning of a claim, let's say that either a buyer or seller brings to you, what's the first thing you say? Send me.
It's really the contract. And any escrow instructions, any amendments, any requests for repairs, any concessions that are made. And then I like to see the communications back and forth, and text messages also are important. So generally, it's the contract and the communications between the parties is the first thing that you ask for.
Back to the dual agency, I feel like that's got to be the number one cause of agents being involved in lawsuits, is it not?
It is a huge problem, and any case where there's a dual agency, some lawyers know what to do with it, some don't. And I've seen so many cases where they say, well, he or she's a dual agent, and that's about it. And you have to do more than just say they're a dual, and they think that it's an automatic when there's a dual agency. I think that it's tricky. I think that there's there's duties relating to both, and there's a civil code on point with respect to your responsibilities, but there's a heightened sensitivity when you're a dual, and there's a decision that came down, which a lot of lawyers are using, relating to what you should and shouldn't say when you're a dual.
Right, but with dual agents, with like if I am representing the buyer and the seller, my move is to call you and say, hey, help me dot all these I's and check these T's.
I think that's correct.
Of course you do.
It's
so
the
wait.
move because
I know you.
We had a situation a few years ago. An agent of ours repped both the buyer and the seller. A few months after they closed, the buyer discovered a broken pipe under the house that since led to a ton of mold and damage to the house and the foundation.
Sucks.
When they sent a plumber to fix it, they discovered that it had been patched, and like a temporary patch to the problem. And which he failed to deal with, and he failed to disclose. They found out, they're like, we've been here, we patched this. They did not disclose it. That's bad news for the seller.
Yes, I think that that's very bad news. I think that when you have a repair or you have a history of leaks or anything, you should disclose it so that the buyer has an opportunity to inspect and a buyer has the opportunity to decide whether they want to buy the property or not. The bigger the problem, the more potential liability is. But if there's someone patching the walls, then they should disclose it.
Yeah, of course. Well, that gets me to while we're on it, how do you advise agents to advise their clients on what to do with the disclosures? I so often have clients say, I don't know what this stuff is. Can you fill it out? And I'm like, absolutely not. This is for you to fill out to the best of your ability and the best of your knowledge. But again, we want to be there as advisors to try and help and guide. Where do you draw the line?
Well, I think on SPQ that the questions should be gone over. It used to be you do it in person. Nowadays, it's a little bit different. But I think it should be done in person. I think they need to fill it out. I think that they need to answer all the questions. I think the agents need to send an email saying you need to answer all the questions fully and completely. And if there are some things that they don't answer, you'll have to remind them they need to answer the questions. And then sometimes people say, is this just a formality? Let me just sign it. The agents have a responsibility to tell them no. They need to answer fully because they're in the best position.
Yeah, my answer to that is always fill it out, do more than you need to, disclose more up front, because you will have a much greater chance of overcoming the obstacle now than someone fighting about something later. That's the last thing you want.
Right, and then sometimes people do note a problem, but they don't note the significance of it, or it's cryptic. And that's where you get into some problems.
Now, if
Yeah,
it's
less is more,
cryptic,
right?
if it's cryptic, but it's been submitted 4 days later, they say, "Hey, can you identify what this means? Please rewrite it." Does that open up that time frame again?
I think that the
Doesn't the purchase agreement allow that for a cancellation right relating to a new disclosure?
well,
Is it a new disclosure? Is the question? If they just say, "Hey, clarify this sentence."
it can open up the contingency period. It depends on circumstances. It depends on what's going on, but it can reopen the contingency to say, oh, yes, this is a problem. We didn't tell you about it before. And commonly, it does open it up. It depends on the circumstances, but people always argue that. But what I see is things like retaining wall cracked, or there was a leak in the basement, and you can't tell exactly what that is. And so it should follow up with it to see exactly what it is. Do you have any reports, and can you tell us some more about it? So a buyer does need to check those things out. And when a seller answers the question, sometimes that's all they know, or sometimes they are just being overly general, which can lead to a problem later.
Well, I want to jump to the AVID for a second, the agent's visual inspection disclosure.
Everyone's favorite.
What kind of weight does that carry? And what should agents disclose? What is taking it too far?
I think that the AVID by itself for a one-off.
What, you got a migraine?
Rain Man.
I was thinking about. I was
counting cards for a second.
I was thinking about a particular case where an AVID was an issue, and
Thank you very much.
so
Andrew, get him out of here.
I think that if you're not familiar with the property and it's one-off time, a one-off thing, it's different than someone who's been with the property and it's traded 3 or 4 times or they've leased it out. Your duty and responsibility with respect to AVID is what you see and what you notice. You don't have to go and tear holes in the walls or
Open cabinets.
or do anything beyond what you see. But I think that AVID alone.
Cabinets is interesting.
You're not supposed to. It says it at the top.
I think an AVID alone is tricky for someone suing because I don't think it's if you've only seen a property a couple of times, it's hard to know, what a problem is and what isn't. But you're supposed to do the AVID in conjunction with the SBQ. The last case that I had, they went over the AVID, but I thought the buyer went over the AVID, but I thought it was ineffectual against the agents.
Yeah, I figured.
I've been told that you don't want to say colors. You don't want to say it's a red stain. You just say there's a stain or something at least our managers over the years. I've been with 3 brokerages. The first 2 fired me. I got half a leg out here, and basically they said you don't want to qualify too much. Just kind of report the news. Also, a lot of agents will put nothing noted. They should just leave it blank, right? Or it doesn't matter.
I think that you should go through and fill out on each room and see what you see. I think blanks are probably not recommended. I think in terms of your issue regarding color, I don't understand what you're saying.
Great. You advise agents in general to be very careful with the things with which they communicate, and they should probably say less and stop trying to be such people pleasers in absence of effective selling. They should just get out of the way and let the transaction happen.
I agree with that a lot. I agree with that.
And finally, you got one on the board.
But also, there is, in many cases, you're dealing with people that are fairly sophisticated, that are already have a business background, already know contracts. Mm-hmm. So they know what they want and what they want to get out of the transaction. So
it's intimidating when Mauricio walks by.
Why? He doesn't intimidate me.
No, I just start sweating.
I don't think anyone does, but I do see you at Passover Seder saying to a young child, asking, why is this night different than every other night? And you say it's a very open-ended question. I do see that happening.
Okay.
Do you think the car contract is well written? Are you seeing a lot of flaws?
I think, it does go through certain revisions, and I think there's certain modifications. You don't say termite anymore, and
it's a cancel culture.
Pests.
I don't know. I'm not sure. We used to say it was termites. So
yeah.
But
God forbid, don't say that on the show.
Don't say termites. We're a new show. How about this? I'll give you another version, and you tell me if Billy's clause would have mattered. I was under contract with I had the seller.
A specific case, huh? Okay.
No, it's very specific.
Don't give him a specific.
I don't think I'll answer it, though, but.
No, it wasn't a case. I'm just saying this is a case study in my career. So basically, we were in escrow. And no loan, no appraisal contingency. I'm representing the seller. The buyer's agent calls my partner, my junior agent, and says, sorry, he couldn't get his loan, we're canceling. But he had no loan and no appraisal contingency, and he's saying, well, we're canceling. And he did not say anything relating to the physical nature of the property, the disclosures, the preliminary title report. Is that in contrast with the good faith paragraphs of the purchase agreement because he said he couldn't get his loan when he didn't have a loan contingency.
Nope, they don't have a right.
Let him answer.
I got this.
Okay, you can answer it.
They have no right under the contract.
So, what do you think?
I need more specifics on that one.
What do you mean?
I need more specifics on that one.
Ask me.
It's not.
By the way, we ended up releasing the deposit after a while, but the seller initially did not want to release the deposit because they had no loan, no appraisal contingency. They couldn't get the loan product they wanted and said, we're canceling because of it under inspections. So he withheld signing the release for a long time, for 5 months or something.
Did the seller fail to cooperate in something relating to the loan, even though there was a no loan contingency?
It's like he's playing a chess match.
No.
I think without looking at the case, it's
There was no case, by the way.
problematic to say you couldn't get a loan when there's no loan contingency.
No, I agree with you. That's why he withheld it. However,
I get it.
Let's say Billy's clause was in there unfettered. Would that have absolved?
I don't know the answer.
He's got to read Billy's clause.
I was just curious. Okay,
Don't
fine.
be a moron. If you have no loan and appraisal contingency, don't use that as an out.
Zach, I don't think it's cool to call our audience who turns to us for tips and tell them that the things they don't know, it makes them morons.
No, I don't think our audience. I think our audience.
And also, you
realizes
say a lot of
if
moronic
they
things
have-
on and off this show, and we don't judge you. We're
Yes,
patient
you
with you.
do.
You sent him the wrong email address, and you've been known him for 20 years.
You don't use the AOL anymore? If you have no loan and appraisal contingency, use another excuse to get out of the agreement if you want out.
Okay.
For fuck's sakes, over here. Guy over here. I'll see you in shul. Let me ask a question about leases, because no one likes to do them. No one likes to bother with them, and agents fly right over them because you make no money. You're doing it as a favor. You're doing it as good faith and for the relationship building. There are problems all around.
The leases, the agents do the leases because they want to get the listing, usually. And if the higher end houses they are, the more they feel it's likely that they'll be called again on the sale. There are plenty of homeowners, homeowners that will never sell. So you're going to be in this leasing loop for the rest of your life. And then if you're a dual on leasing, is very problematic.
I'm dealing with that right now.
Very problematic. Be careful of people that want to pay 6 months in advance or a year in advance, unless it's short-term rental, like in Malibu. You got to be careful of those issues, but they're very problematic. There's many times that people also lease. They don't see the property. They come and because they're from out of state or out of the country, they come and see the property, don't like it, and then there's a big fight.
Why is a pay in advance such a problem for our audience here?
Well, because sometimes people do things emotionally, and then sometimes they change their mind. They want to tie it up. They want to make sure they think that someone else is going to lease it. They have other financial reasons for doing it. But mostly, if there's a payment in advance of a long time, more often than not, a problem arises. And then also, if you have to evict them, and their payment of rent is all in advance, then it's harder to evict. And so that really becomes a big problem. And so if you're going to evict them because they're a pain or a nuisance or they're doing things on the property they shouldn't do, then you have to pursue an eviction for reasons other than non-payment of rent. And it better be bad stuff. You know what you're getting. I think when you buy property, I think that in general, Los Angeles and Beverly Hills are safe bets. I think that you have to be careful in the transactions that you proceed on. I think that I don't see even a downtrend like we had in '95 or '08. I don't see it happening even today. So I think that they are safe bets. I think that the agents I saw Rainey on your show. She's right.
Oh, you're a fan. I could tell.
She doesn't watches anything Rainey's in.
That you have to work very, very hard, and you have to know the area. And if you just show up on an appointment, like she says, you've already lost. You need to know what happened with the neighbor across the street. You should walk the neighborhood. You should go there in the night, and you should see what the properties are. And I think there still are plenty of opportunities out there. I think in terms of the legal profession and real estate, I know right away when they're good and when they're not good. And I know within seconds.
What are your thoughts so far? How am I doing?
I'm talking about lawyers, not real estate agents.
Oh, sorry. I'm very self-absorbed, and I wanted to get your rating and your approval. You brought some stuff with you with regard to ULA and wildlife. Anything you want to talk about or add?
No, I thought you were going to ask me questions about the two things. So
we reported pretty deeply on them.
Oh,
I mean,
okay.
what we know is, correct us if we're wrong,
Yeah.
wildlife, as of September of 2023, we don't know when the next vote's coming?
That's right. The city council does not have it slated for the full vote, but it passed at the committee level.
Yeah,
so
we watched that. We actually tried to get in. They wouldn't let us in. It was... there were a lot of people trying to get in there. We did an episode on wildlife, just on some of the things that we thought were unfair, particularly like the little old ladies that have owned their homes for like 50 years.
Yeah.
Now they're going to maybe lose 2/3 of the value based on what their teardowns can be redeveloped as. You know, that was their nest egg.
It was.
It was, yeah. And then also turning to ULA,
Yes.
Any thoughts you would share on the fact that it's trying to be overturned with these antitrust lawsuits?
I think that there are. I'm familiar with the lawsuits. I know what's going on with them. I think it's going to be problematic relating to the effect. I think that from an economic standpoint, Beverly Hills is a better bet than LA now. And before the ULA went in effect, there was a lot of manipulation relating to how you handled the ULA. But I think the problem is that the police powers are very broad, and so it's going to be, I think, an uphill challenge.
When you say an uphill challenge, you mean to overturn it?
Yes.
Yeah.
And then when you said Beverly Hills is a better bet than LA, what did you mean by that?
I think that the values in Beverly Hills are better. That's what I mean.
Oh, understood.
And
okay.
it doesn't affect Beverly Hills.
Right,
at least not
that we
now.
got. Yeah, okay, understood.
Did you want me to rate you now?
Yeah, it's good timing.
Be careful. I'm
You
from
know-
Philly, pal. Okay.
He may be from LA, but he lives like he's
What a
from New
ball
York.
buster.
You know what?
And he loves his own joke for a long time. That was a long chuckle.
Because you didn't get it.
Well, sorry, counselor, you didn't make it clear.
Okay.
I'll tell you, if people want to sit through
get
this. People want to sit through this deposition.
What are your
they're gonna find
thoughts
some big
on
tips.
replacing Zach on the show?
I'm 100% in favor.
He needs
of it.
more info. You need more info. You can't make a judgment. Don't advise.
Before we wrap up, do you have anything else you want to ask?
Well, I think what I love about Aviv.
Oh, this is going to be an outro.
No, this
Love
is
fest.
other attorneys
Lower.
and agents overperform and get in the way of the deal.
Totally.
We see
Yeah.
this all the time.
Yeah.
Your job is similar to ours. It's to advise, to guide, and let the buyer and seller make the decision. That's it. You give them the information. You present them with the rules. You let them make the decision. And every time people see attorneys, they get scared because they change a contract. They try and kill the deal. Agents do the same thing. I think the good ones, the good attorneys, give it the best advice and let the seller and buyer make the decision, which is what we do.
I think that's right. I think that I like when the properties trade. I like when the deals are done. I think it benefits everyone. I think that it's a good field. If there's truly something that can't go forward for one reason or another, then really we need to move on from the transaction, buyer or seller. But yes, when we were in law school, they said that the agents when the agent in a real property, they said when the agents they're taught when the lawyers come in, the deal will die. And no, I don't have that philosophy.
You don't.
Try and
I
keep
know
it.
you don't.
I don't feel that way. I find when our colleagues say, like, the agents or the business managers are deal killers, I think that it comes from a place of scarcity. I think it's okay to add in another layer of protection for the consumer. And I think many times our schlockiest of colleagues in Zach's and my space, I think that they forget that we have a code of ethics. And one of the, I think, the first rule is that we have a duty to the consumer. And I think that generally speaking, meaning like 99.9% of the time, the attorneys as well as the business managers are there to protect the consumer. That's
So
not a
are
bad
we.
thing.
So are we. And that's what we do.
I think that's well said.
But I think,
Finally, no one's even watched to this point, and I finally get a compliment.
and we're going to edit that part out. So
Hilton and Highland and the agency are no longer enemies, okay? I know you were in-house there for a while, and I know where your loyalties lie, but I can be a friend to you.
he's with me now.
You know.
Ben, take us out before he gives us another deposition.
Are you sure?
Yeah.
Guys, I hope you enjoyed this episode that was not only action, insult, and information-packed with counselor Aviv Tuchman. Did I say that right?
You did. Thank you.
You're welcome. Just want to make sure I said it right. I don't want to be, served on Tuesday after Yom Kippur. It was Aviv. Where can they find you?
On Pico Boulevard.
There you
Where
go.
can they? You love
Next
your
to
jokes. He
Factus.
loves it. I think I love him loving his jokes the most. Wait, do you have like a website or an Instagram that you maybe?
Definitely no Instagram.
Instagram this
Sorry,
guy.
I'm just checking.
You can email me at atuchman@tuchmanlaw.net. That's what you can do.
Okay, that's where you can find him. I'm scared of him. I
But-
don't want to be on the other side of it. Yes.
But I may or may not respond to you.
This is
Fair
the
enough.
calmest and the most contained I have ever seen. you
Really?
Before. Oh, he calls and I go like this and it's not on speakerphone. And everyone's like, "Can you take it off speakerphone?" I'm like, "It's Tuchman."
Seated next to at Zach Goldsmith 24. I'm at Ben Belek. Thank you for tuning in. And
If you have a problem, Tel Aviv. Super bien.